Okay, we're good? All right, welcome everybody to the July 15th, Porter Board of Zoning Appeals meeting. You could all face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, can we have a roll call, please?
Mr. Kremke,
Here.
Mr. Mallender,
Here.
Mr. Wagner.
Here.
Okay, we do have a quorum. Minutes from our June meeting. Are there any changes or comments to those?
Move we accept them.
I'll second.
Okay, a motion and a second. All in favor?
Aye.
Okay. Next item on our agenda is called audience participation. That's for someone to approach the board for something that is not already on the agenda. Okay, seeing none, we'll move forward. We have some old business to complete from our last meeting in June. We have some findings and the facts to review for public hearings. The first is from BZA case 26-01 for Joshua Schneider. Has the board had a chance to review these? And if so, are there any comments or changes?
I'm gonna abstain since I recused myself from the discussion, was out of the room, so you don't need me for this.
I make a motion to approve.
We're not going to have a second on this one, so we'll have to
Can we?
continue this one.
Well, two things, right, and it'll get, I guess, we might as well fast forward a little bit to remind anybody or advise anybody who's on the agenda that since there's only 3 board members, you need a unanimous vote this evening for something to approve or pass. But if you don't have a second, or you don't have 3 votes tonight, you can't move forward with that. So whether you do or do not get a second, you can't move forward, and he was a no vote on approving it.
So I would be, yes.
So that one will just get held over.
Okay. All right. Maybe we should explain to the audience too, more detail, what you said, that in order to get something passed tonight, you need a unanimous vote since it's 3 of us. Normally, we have a 5-member board, we do not tonight. So if that's a concern of yours, then we can move your case till next month, otherwise we can hear it tonight with everybody. Okay? Or do what we need to do tonight, whether we hear it or not. Okay. Next, findings of fact are for Brian Lewandowski. That is case 26-02. Any changes or recommendations?
No.
No. Can we do any of these tonight?
If you get a motion, a second, and all 3 of you vote to approve or deny.
Oh, I know we just disagreed on all of them
Well,
last time.
yeah, this one I will be a no vote as well, because I voted no for the petition.
Hold up.
Oh,
Yes!
All right, there we go, guys.
Saved by the bell.
Jim, you saved a bunch.
So the first one will stay the same because you recused yourself
Correct.
and you were no vote. But you could perhaps make your motion for the second matter.
Jim, we are reviewing the findings of fact for Brian Lewandowski right now.
Okay, thank you.
I'll give you a second to look at it, I'll talk slow, but I will move to approve the findings of fact. 26-02.
Yeah, we'll give you a minute, Jim.
I'll second.
Do you have any changes? No comments?
No.
Okay, so we have a motion and a second. Can we have a roll call?
Mr. Erickson?
Yes.
Mr. Wagner?
Yes.
Mr. Mallinger?
Yes.
Mr. Kremke?
No. Okay, we then, again, have findings of fact for Dennis Renee Heinlein, petition 26-03. Same thing, questions, comments, or motion?
I move we accept the findings of fact for 2603.
I'll second.
Okay, roll call, please.
Mr. Erickson?
Yes.
Mr. Wagner?
Yes.
Mr. Kremke?
Yes,
Rob said yes too.
you forgot a guy.
Mr. Mallinger?
Okay. And the next one, we just accept this. The next one, we still approve this as,
Yes, as
as a
denied.
rejection, as denied,
That's right.
okay?
So a motion to approve the findings of fact is affirming the rejection.
That's right.
I move we approve petition, the findings of fact and petition 2604.
No.
So we have a motion to approve the rejection on the floor.
I'll second.
Okay, motion and a second. Any comments? Okay, another roll call.
Mr. Erickson?
Yes.
Mr. Wagner?
Yes.
Mr. Mallinger?
Yes.
Mr. Kremke?
Yes. Okay, we have an appeal of a building permit on our agenda. I'm going to read its appeal of permit issued for 220 Roskin Road for a fence and asphalt removal by Alyssa and Gabriel Medina and Carol and David George, represented by attorney Dwayne Hartman. Is the filing timely? Is everything in order on this?
It is not, we have a jurisdictional issue, both the appealing parties and as well as the neighbor who received the permit have counsel here this evening. I would suggest that you at least let Mr. Hartman introduce what it is and while they're here. But as I've discussed with both of them, my recommendation to the board is that you consider whether you have jurisdiction to consider that, which would be a threshold issue of whether you can move forward and actually hear the appeal of the issuance of the building permit. I will defer to Mr. Hartman to explain in a little more detail, and then you can decide how you want to proceed with that. But ultimately, they're here, for those not completely aware, and Mr. Hartman pointed us out before, they are appealing the issuance of a building permit for the installation of the fence and removal of some asphalt that goes along with that. And so they timely filed to be on the agenda, but there is a question as to whether there's a timely filing of the appeal as it would be before you. But I do think it's appropriate to allow him to introduce himself, and then can go from there of how you want to proceed.
Sure. Mr. Could you approach the podium, sir, and just give us your name and address for the record?
Yes, thank you. First of all, my name is Dwayne Hartman. I'm an attorney in Valparaiso, Indiana, with the law firm Blatchley, Tabor, Bosick, and Hartman. Been practicing since 1967, and am still mostly part-time today. I have a handout that I'd like to share with each of you. It gives you the history of why we're here and what happened, and then I'll explain to you why I think you should deny the the permit in the first place. That's part of what's in here, but what Mr. Willoughby was talking about was the fact that we didn't get notified of the permit being issued, even though it affects our property, until a month after it was issued on the 26th of June. So I share with you, Council, and what you advise.
And while Mr. Hartman's passing that out, again, you're the decision makers here, so I want to make sure my job's to advise you. Each of them have counsel to advise them. My suggestion is before you allow Mr. Hartman to get into the heart of his presentation and his discussion of why you should override that or rescind that appeal, that's the jurisdictional issue of which we need to speak about first, but certainly worthy of him explaining some of the background. And then before perhaps he goes further with that presentation, my recommendation is that you consider the jurisdictional issue.
Okay.
Thanks.
Okay, so if you can just give us a brief background, it would be appreciated.
I will very much try to be brief.
Okay,
I'll try to
appreciate
be
that.
brief, actually, in here. But what this is all backup to what I have to tell you, okay? It's the documents are showing that there is a subdivision, okay? And in the middle of the 220 over here and 240 and 260 Ruskin Road, there is a platted street called Clark Street, okay? Clark Street runs, as near as I can figure out, north and south, and it is that street, okay, that we are arguing about, and the use of it and the access of it to basically 240 and 260 from property that is legally owned by virtue of a vacation order by 220. That's these folks. Okay, now it's all in here. Okay, so I have in here the bottom portion of the plat, which is Exhibit A, about the third page in this document. On the second page, Exhibit B, there is a two-page document that comes from the Porter County Assessor's Office that in the kind of the left-hand.
Sorry, Mr. Hartman, not to be disrespectful, but I just want to caution you that we're not getting down the road where you're actually having a hearing on this matter when there is a jurisdictional issue that
We understand.
precludes you.
I'll explain
in my
all that.
opinion.
Yeah, because what we're here to hear is about an appeal, not about a dispute or about property issues, things like that. I don't want to get too far off and people get confused, or the board think that we're talking about how to resolve this dispute in property or access and things like
The
that.
ultimate decision maker is going to be the Porter
Correct.
County Circuit Court.
Correct.
Okay.
But I just want
The
to.
question becomes is, they filed a permit, the permit was granted, we didn't know anything about it until the day they came out and put a fence up across our driveway.
And so there's a good portion for me to lead into that. They filed an appeal, right? And they, as I've indicated, which may be a little confusing, but because I do not have the ability to determine and ultimately make a decision on whether they have timely filed the appeal, but they did timely file to be on your agenda. And they filed documentation with Tammy, with the clerk's office, to be on the agenda tonight for you to consider. Now, a permit was issued, again, for a fence installation along with asphalt removal. There's a dispute amongst them, the bottom line is they don't agree on who owns what and who has access where, and that is not in your purview. You're not here to mediate. You're not here, and so what they're asking you to do is to overrule or override the building permit issued by Mr. Berry after consideration, and that is why they're here. Now, the jurisdictional issue for you is whether that appeal was timely filed. You do not have an obligation, and Mr. Hartman and I have talked about this, but just because he's rightfully made that point, they're not entitled to notice from you. This isn't like a public hearing or anything of that sort. The person who would have standing for that notice and it was involved directly is the applicants or Mr. Kursek's clients. And sorry, he hasn't introduced himself, but Tim Kursek is counsel for those who have the permit. And so you're not required to give them notice. The onus is on them to, and this is no slight and it's not choosing sides, but my advice to you is the onus is on them to be aware or inform when it is or isn't, and I understand the position that it does or doesn't put, one side or the other. So the long and the short is, there are 30 days from the issuance or the decision from your building commissioner, right, from the building department to appeal that decision. You do not have to give them notice of when it was issued. The building permit was issued no later than the 26th of May, all right? That is the latest possible date that is applicable here when it was picked up, paid for, et cetera. The appeal was paid or filed on the 29th. They had 30 days. So it is my opinion that this is not properly before you, that the appeal was not properly or timely filed, and that you do not have jurisdiction to entertain this. And if you were, and again, that's my opinion, then the other side may appeal your decision. Either way, somebody's likely to appeal your decision. And we can't control that, and that's,
There's already a lawsuit filed, okay, in the circuit court to determine our access, that we have valid access to the property, that they want to tear the driveway out.
which again, in the things that you've heard, but they're not material to this appeal, is there's an acknowledgement that they own that road tonight. That has been said already. And two, they have a private dispute to be determined by the court. And again, it's not your charge. I understand this has been going on quite some time, but your job is to determine, and it is, you get to determine whether you take my advice and want to move forward with it, or you determine that it is not timely filed. It is my opinion that this appeal is not properly before you, which then does not give you jurisdiction to move forward.
I would make one comment. My client will testify that on 3 different occasions, she received written notice from Mr. Berry that no permit would be granted without her notification. That's just not fair, guys, okay? That's just not fair, okay? That's why we're here. And you have to make the decision whether you want to listen to me or not. But you're not going to make the decision on that, on whether or not we have a valid easement. Correct. Is what it is, basically. Across their property.
Correct. Okay. Do we have questions, comments, board?
So, I don't think so. What were you guys looking to get out of this tonight?
Well, let me answer that so we don't get in what they're here tonight. If you were allow them to move forward, they are appealing Mr. Berry's issuance of a driveway permit to Mr. Kursak's clients.
No, to tear the driveway.
Hold on,
out.
hold on. They're here, the permit that was issued was to place a fence, and it includes the removal of asphalt on their property. And again, there's a dispute regarding access and who has that. But they are looking, if Mr. Hartman had his way as filed, then you would hear what he has to say. You would give Mr. Kursak's side the opportunity to rebut or present their position on it, and then you would make a decision essentially to uphold and affirm Mr. Berry's issuance, or to override it and mandate that he rescind that. Right now, by virtue, because the statute's not exactly clear, automatically by them filing it, put a stop work order on their work. Even though they have a permit, they haven't been able, because the statute says that. So that, until you make a decision, everything's on hold. Back to the other. So you have to decide if you have the jurisdiction to move forward. That's a threshold issue. And if you do, then you can proceed. If you do not, then you vote that that it's not, you're not going to entertain it, and you deny that appeal on the jurisdictional because it's untimely. And then they do what they're going to do with the courts.
Which will mean no construction.
No,
That's
it
not-
doesn't, no, it
We've
doesn't
already
mean
got
that.
a fence across our driveway. We can't get up to our house from Roskin Road.
And it doesn't, it doesn't mean no construction, because the stop work order only happened by virtue of, normally, and I don't wanna get too far in the court rules and all of those things, you know, it might be that someone has to post a bond or do, when you interrupt work. But in this instance, the statute says automatically till you make a decision, or if a court orders. So if you make a decision that there's no jurisdiction, or you uphold Mr. Berry's issuance, that stop work order can be lifted. But a court could impose one, and we can't control that, right? That's up to the courts to decide.
So,
Well, not taking any sides, I don't see any reasons for us to listen to it till the court decides.
well,
That's what we're trying to do, is get to the court as quickly as we can, as fast as we can.
I understand.
Without there being a fence across our driveway.
I understand.
yeah, I understand.
And they do have a pending, a deck action, right, a declaratory.
We do.
So
Yep.
they do have a matter pending before the court. And they could appeal, one side or the other is gonna appeal your decision and likely include that, and that's their prerogative. The timing likely doesn't line up the same, but, you know, that's, again, you don't get to control that. Whether you decide to move forward, whether you don't, whether you affirm, whether you don't, either way, there's going to likely be an appeal of your decision, and that shouldn't sway you to not move forward or otherwise, right? So you have a duty and a charge.
And we have a duty to appeal to you before we can go to court.
Gotcha. But if the appeal, if this appeal is out of our jurisdiction because of the timeliness of having it filed, what weight does our decision carry anyway? If we would decide to go around that?
Well, that would be up to
Yeah.
Mr. Kursek's side to argue
Yeah.
before the court.
I'm just
Right.
asking the board, just throwing it out there.
Yes, clarifying, appreciate it.
So do we need a motion?
Yeah, you need to vote on this like you would a normal matter, a motion, a second to, but I think you
Allow
need to.
him, or to allow it to continue,
Well,
or?
Well,
To-
for
to-
instance, I'll give you a for instance. You could make a motion to allow this matter to move forward and find that you have jurisdiction to hear this matter. I believe that that's the threshold issue. You could make a motion to deny this appeal and not move forward because you don't have jurisdiction. Those are two examples, but that is the threshold issue. You could say, Chris, we're not listening to you, and we're gonna hear this, and we have jurisdiction, and we're not gonna vote on that. But that's my opinion, is that you should make a determination that you do or do not have jurisdiction first.
I'll make a motion we don't go forward, not taking either side, but I don't feel comfortable until this court thing. I just don't.
so that,
So is your motion that you deny the appeal because it was not timely filed and you do not have jurisdiction is what I would suggest, if that's what you're saying? But
Yes.
if not, let's have a
No,
discussion so I can help.
That's the way.
If that's the motion, then I second it.
okay, motion a second, any more discussion? Okay.
I hope, it's just this, that I hope the parties find a resolution for all of them as soon as possible.
Yes,
Mr. Erickson?
Yes,
Mr. Wagner?
Yes.
Mr. Mallinger?
Yes.
Mr. Krempke?
excuse me. Okay,
Thank you.
okay, we do have a public hearing. Jory Fitzgerald at 3001 Duneland Drive.
Yep, yep, yep,
What?
preliminary.
Preliminary.
Oh, I skipped, sorry. I check marked the wrong thing. Okay, we have a preliminary hearing. Troy Clark, address 341 East, US Highway 6, requesting a developmental standards variance or 3027 Florentine Street to allow to build in a 15-foot setback and overhangs for a house. Okay, approach, then give us your, just state your name and address again for the record.
Yeah, my name is Troy Clark. My address is 341 East US Highway 6, Valparaiso, Indiana. I'm here today to talk about allowing us to build within the 15-foot variances, and then also to allow us to have overhangs over 3 feet. Those are the two things that I'm here for today.
How much of a variance are you requesting? I know it says into the 15-foot setback, but how much do you need?
Well, if you look at the plans, so some of the, there's a roof line that stretches out over that creates a covered patio, and then where that fireplace hits on both sides on the back, and then, or on either side, I think it's east and west side, those fireplaces land on pretty close to the property line. That's kind of the only thing that's the major thing, as far out. And then, there's a little corner that we come out with that's on the south side that makes that property kind of aesthetically equal. Otherwise, there'd be a big chunk taken out of it if we were kind of staying with those parameters.
Okay. Could you,
I can elaborate.
could you please? Thank you.
Yeah, so we can calculate the exact amount that's over, because right now, the preliminary drawing, it's kind of hard to do
Yeah, it was-
math on it. But it's, it's essentially an old bungalow house in poor shape with a very short basement. It's 3.7 feet from the south property line. It's adjacent to the house that Mr. Conman did the remodel on, and it's 2 houses down from Mr. Pape's house that was also in here before. So he's got a non-conforming structure, and we've gone through probably, 5 sets of plans, I think, looked at on it. So any work he does on the house that's in poor condition is gonna require variance. You just can't really do much of any remodeling to it without getting a variance, because it's too close to the property line. So he laid out a.
Can you explain
Yeah.
that point exactly?
Yeah,
You can't do
so-
any remodeling without,
So his south wall, and again, the house isn't in great shape. I mean, I'm trying to be nice, Troy.
I've walked by it.
You know, it's an old house, it's an old house, it's not in wonderful shape, it was, you know, not well maintained, I'll say. And so with the low, everything's short in there, so if you're gonna remodel something on the south side and try and redo the walls and even shore up the walls, do any work on the walls, you're gonna need a variance. You're within 3.7 feet of the property line. So just to remodel that is going to be problematic. To change the roof line or do anything, get more headroom in the house, he'd require a variance. So he laid out, after several sets of plans, he laid out a single-story house with actually a flat roof that's sort of pitched like this. There's 2 houses directly behind him, and he's been very cognizant of not trying to block the view of the houses behind him. So his proposed house is actually shorter than the existing house. If he takes the roof off and lays out the new roof, he's shorter than that, so he's not blocking anybody's view. He went out to both sides, east and west sides, and put, well, I'll just say large overhangs with fireplace and decks in there. Those protrude into the side yard setback. So we can calculate the distance that protrudes into the 15 feet, but they're in the 15 feet on both sides, so. And then he can only go so far to the north because he runs into the toe of the dunes, which is the platted line for, you know, national parks. He can't go any further than that. So he hasn't made a massive house out of it. It's just a 2-bedroom house. But it's just a new version of what you know, a new version of a house that's remodeled. The one next door, Mr. Conman tore down almost the entire house and rebuilt a whole new house on the old foundation and expanded it, so that's right next to it. Mr. Pape's house that's right behind him was the one that's wedged up against the west property line, and he needed variances to rebuild his deck and add onto the house. So they're all in the same vicinity of non-conforming older homes that need some work.
Okay.
And I think it's very difficult to do anything in that area because of how those houses were built.
He also has no driveway, that's a house you have to walk to on the pathways. When he does any construction, he has to get permission from National Park to drive down the beach, so it's a difficult place to work. Mr. Pape is having the same kind of issue behind him, although he doesn't have to be on the beach. Getting any equipment back there without a road is really hard to do. But we've spent a lot of time looking at it, and he's, very cognizant of his neighbors and the situation he's in there, so.
Any other questions, board?
Any questions?
So the question is, should we set it to preliminary hearing?
Correct.
I would make a motion, we set it to, pardon?
Public hearing.
Public hearing, to public hearing at the August meeting.
I'll second.
Okay, roll call, please.
Mr. Erickson,
Yes,
Mr. Wagner,
Yes.
Mr. Malinger,
Yes.
Mr. Krempke.
Yes. Okay, so next month, and I know, Tammy's gonna get you set up for your public
Can I
notice.
make one comment out loud?
Yeah.
I thank you for the explanations about the development standards, which clearly,
We can get the dimensions of that.
yeah, the drawing's pretty good, and I think they'll be good. It's just that we are also asking for the variance will also be to 26110, because it's non-conforming property.
Yeah.
So we would be saying, normally it says, you may be maintained or rebuilt
Yes,
to the previous square footage using the same footprint, period. So in addition to setbacks, we also would be giving a variance to that part of the ordinance. So that's something that you'll want to address.
you can add that to the application.
Yeah. Yeah.
Yeah.
He'll help you.
Excellent.
Right, good point, thank you, sir.
Will you help me with that tomorrow?
Okay, so now we will move into the public hearing for Jory Fitzgerald at 3001 Dunlin Drive, requesting a developmental standards variance for a 10-foot variance to setback from the property lines. An ordinance requires 15 feet setback from property lines. This is for a covered outdoor patio / cabana.
Good evening.
Evening.
My name is Steve Francis with Henry Group Architects. I'm here representing the owner, Jory Fitzgerald. As you stated,
Before you go forward, sorry, just want to make sure that you know that notice is sufficient,
Thank you.
and they've also submitted a power of attorney to allow him to make the representations.
Okay,
yeah, the owners are, the property in question is 3001 Dunlin Drive. The owners wish to demo the existing, there's an existing little gazebo where a hot tub sits now along the west property line. They want to demolish that and build a covered cabana with outdoor kitchen, little dining space, and then they're gonna put a pool through. They wish for a reduction in the side yard setback, the west side, from 15 feet down to 5 feet for that building. There's a little bit of a special circumstance because there's a roadway easement to the west side that's never gonna be a road. It's a walking path that goes down to the beach at this point, so there's a, pretty large side yard between her house and the house directly to the west. A little bit of a odd circumstance, but that's the way the lay of the land is. So they're asking for this, variance for that side yard to be able to build this building and be able to get the pool centered on the house, so it looks correct.
okay. Thank you. We will open the public hearing at 6:03. Is there anyone in the audience who wishes to, you can go ahead and we'll call you back up. Yeah. Anyone in the audience who wishes to speak in favor of this petition? Anyone in favor? Going, gone. Anyone in favor? Okay, is there anyone in opposition to this petition? In opposition? Last time, anyone in opposition? Okay. So, 6:12, do I close the public hearing at this time? Okay. So public hearing closed at 6:04. All right, Mr. Mandan and Mr. Berry, comments before we get going?
Well, I sent you a memo on this, and
Yep.
I'm not gonna go through the entire memo, but I do wanna, just for the benefit of the folks in the audience, and maybe to remind the members as well, of what a practical difficulty actually is. Normally, the first two items, or first two requirements of a variance are usually difficult to ascertain whether or not they are satisfied or not. But the third one is very specific when it comes to practical difficulty. And what it means is, the property owner proposes to use the property in a reasonable manner, not permitted by the zoning code. The plight of the landowner is due to circumstances unique to the property, not created by the landowner. And the variance, if granted, will not alter the essential character of the locality. In this case, in my opinion, a practical difficulty does exist, primarily because of the significant limitations of the gazebo and interior condition and the lack of storage. And the approval of the variance is recommended.
Anything to add?
So I think you're all familiar with the house, but we call it the glass house. It's essentially a bunch of sliding glass doors with some rooms inside and very little storage. It was built on 4 lots, and then there were 4 lots north of it that were eventually added to the property. So the 4 lots that it started out on, the house kind of sits in the middle, and then there's no setback, there's nowhere to put anything. So everything you would do ends up in the 15-foot setback. So it's just like Jim said, it's practical difficulty is the site. The road adjacent that he was speaking of, which is actually not a platted road, it's a platted right-of-way, it's not a town road, it's considered a driveway and a walking easement, goes straight downhill to the north, and there's nowhere to put a garage or anything on this property unless you got a variance. And then this building they were talking about was essentially rotting and falling apart. So to replace that with some storage and I'll call it a pool house or gazebo, it's going to end up in the setback. The lots that were added to the north, essentially combined into it, gives them now ample property to calculate lot coverage, so they don't have any lot coverage issues. But at the end of the pool, it goes straight downhill like this. So it's practically, you can't build anything on it, it just helps with the lot coverage. So like Jim said, it definitely meets the practical difficulty.
So I have a question, because I want to get clarification on this. I come to the same conclusion, but I have different reasoning, and I want to test it, because when we talk about things once, it'll come back again. I'm going to start in reverse order with what Mike just said. I'm very familiar with the property. To put another building on that piece of property, it's got to be on one side or the other. It cannot be to the north. It's absolutely unbuildable. It's a 35-degree slope.
Right.
That is a unique aspect of that property, which says, okay, I can have an accessory building, but I cannot put it anywhere else. That is my practical difficulty, it's unbuildable. That's the reasoning that I come to, where I arrive at the same conclusion. I would like help in understanding the other reasoning, which is, I have a building, it's deteriorating. I can build it again, even though it wasn't in an acceptable spot. Is that a valid reason for a practical difficulty, that the building is falling apart? I mean, all buildings fall apart. So, I mean,
Are you speaking of this one or the last one?
what I am uncomfortable is arriving where we would write down the findings of fact for this one that says, well, your building's falling apart, so that's a practical difficulty. That seems like a precedent that I would not want to say is a good reason to get a variance.
Just to put up an accessory structure, they have a practical difficulty, whether it's falling apart or not.
Exactly.
So you can leave the first part, falling apart part off, yeah.
Right.
It's just they have a structure that's failing. There's no storage on this property. Tiny closets, and then otherwise it's just.
There's neither storage nor privacy
You know,
on there.
not much right. So there's no accessory structure, there's no garage, there's no storage. So to have storage and have an accessory structure, they would have to get a variance, yeah, regardless of the reasoning behind it. You know.
Cool.
Good question.
Any comments, questions? And we're ready for a motion.
With the understanding that the findings will record the practical difficulty of an unbuildable lot, then I would make a motion that we approve the variance for this outbuilding.
I'll second.
Okay, can we have a roll call, please?
Mr. Erickson,
Yes,
Mr. Wagner,
Yes.
Mr. Mallender,
Yes,
Mr. Krupke.
Yes. So findings,
Well, they have some proposed findings, and it doesn't happen often, but they are sufficient. And based on your logic, that because of the positioning of the house and the lot, for that practical difficulty, that I find them to be sufficient if you were to adopt their suggested findings, and move forward.
oh, that's unusual.
It is-
Very
it is,
unusual.
so.
Yep.
do you want to read them? The number 3, one of the.
Yes, I will. Okay. I'll just read, if I'm gonna read one, I'm gonna read them all. The board finds that the developmental standards variances requested will not be injurious to the public health, safety, morals, and general welfare because of the facts shown as follows. The variance requested poses no risk to the public, as there will be no material change to the existing property, but for increasing the size of the existing covered outdoor area. The board finds that the use and value of the area adjacent to the property included in the developmental standards variances will not be affected in a substantially adverse manner because of the facts shown as follows. The neighbor's property to the west is not affected because there is a road, Dearborn Street, and a deep shoulder between the neighbor's property and the proposed new structure. Neighbor to the south will also not be affected, as the proposed new structure is set back more than 70 feet from the road that separates the property. The neighbor to the east is not affected because the grade of the property sits below the sight line of the entire lot located at 3001 Dunewin Drive, and there are several lots between the proposed structure and the neighbor. Now, here's the one. The board finds that the strict application of the Town of Porter zoning ordinance will result in practical difficulties in the use of the property for which the variance is sought because of the facts shown. The positioning of the existing home relative to the lot does not provide adequate space to construct a covered area with storage unless the variance to the setback is granted. Does that satisfy you?
Yeah,
Yeah, and
Okay.
again, my point tonight is only if you're inclined and not reinvent the wheel. And so I try not to get involved in stylistic things. It hits the major points that would cover you in terms of making and supporting your decision. Of course, you're free to make amendments to those tonight, or to direct me to prepare some that you would prefer to have in your own language.
So,
I move we accept them as written.
okay. Do we have a second?
Second?
Roll call?
Mr. Erickson,
yes,
Mr. Wagner,
Yes.
Mr. Mallender.
Yes.
Mr. Krupke.
Yes. Okay, next item, update from attorney or board comments. Anything else, anybody?
Nothing else for me. I used up all of my time.
We appreciate your time, Mr. Willoughby. Thank you. All right, that said, do I have a motion to adjourn?
Make a motion to adjourn.
Second.
All in favor?